commemorating International Justice Day, hosted by Mar Gregorius College of Law. Mar Gregorius College of Law is a center of excellence in legal education. The college was established in 2012 as another milestone in the glorious Mar Ibanez Vidyanagar campus. Now, I invite my colleague Swati to deliver the welcome speech.
Warm greetings to one and all present here. It gives me immense pleasure to welcome you all to this program on behalf of Mar Gregorius College of Law. Today, 17th of July, the world is celebrating the International Justice Day, commemorating the day of adoption of the Rome Statute, the founding treaty of the International Criminal Court, which seeks to protect people from genocide, war crimes, crimes of aggression, crimes against humanity, and to build peace and security worldwide. On behalf of Mar Gregorius College of Law, I extend a gladsome welcome to Professor T.R. Subramania, the guest of honor for today's program. Sir, we are so honored to have you as the speaker today. Welcome, sir. It's my pleasure to welcome Reverend Father Dr. Koshi Isaac Punamutal, the director of Mar Gregorius College, who doesn't require an introduction as he has always been the pillar of strength behind every event. Welcome, Father. Now, I would like to welcome Professor Dr. John P.C., Principal, Mar Gregorius College of Law, who has always been an inspiration to all of us. Welcome, sir. I welcome Professor Dr. Thomas Kutty, PG, and Professor Ramchandran Nair, our Vice Principals, who have been giving all their support throughout. Welcome, sir. Our beloved Professor, Dr. Jijimon V.S., the head of the department, without whom this program would not have been possible. With immense pleasure, I welcome you, sir. Last but not the least, I extend my sincere welcome to all faculty members and attendees present here. Once again, I welcome all of you to this program. Thank you.
Thank you, Swati. Without further delay, let's welcome our guest of honor, Professor Dr. T.R. Subramania, sir. Professor Subramania is currently serving as the Dean of CMR University School of Legal Studies, Bangalore, after serving as coordinator and research fellow at the Center for Regulatory Studies, Governance and Public Policy in the WB National University of Judicial Sciences, Kolkata. Prior to this, he was the Vice Chancellor of Karnataka State Law University, Hubli. He has also been the Professor of International Law at West Bengal National University of Judicial Sciences. He was a Vice Chancellor in charge of Bangalore University, Dean and Chair and Registrar in charge of Administration of Bangalore University. In the international level, Professor Subramania has served as legal advisor to the Kingdom of Bahrain for over 7 years. We are all eagerly waiting to hear your lecture, sir. We humbly welcome you to start the session.
Okay. A very good morning to all of you. Reverend Father, the head of the institution, Professor D.D. Mohan, and the respected principal and dear students. When we speak about International Justice Day, remember the history of its origin had started much before the adoption of the Rome Convention which was adopted in this century in 2002, which came into force. Now, I just intend to draw your line before. Can you hear now? I intend to draw your attention mainly to the establishment of a court which is known as the Permanent Court of International Justice. Now, the First World War broke out between 1914 to 3 years before, 4 years, and the Treaty of Westphalia, the Treaty of Versailles was concluded. Soon after the conclusion of the Treaty of Versailles, remember, the thought of establishing a permanent court, which is known as the Permanent Court of International Justice at The Hague. Now, before the court was constituted, the members of the framers of the League of Nations appointed a committee. And this committee is popularly known as the Root and Fillmore Committee. And the Root and Fillmore Committee were responsible in drafting the Statute of the Permanent Court of International Justice. Now, the Statute of the Permanent Court of International Justice came in, and afterwards the court started functioning from 1921. When I speak about the court itself, remember the Permanent Court of International Justice was seated at The Hague, and it had given wonderful decisions. And not only it gave decisions, but it had given a few wonderful advisory opinions as well. Now, what exactly is the contribution of the Permanent Court of International Justice to the international justice is the fundamental discussion which I just intend to place before you. Now, there were several cases came in. When the several cases came in, the Permanent Court of International Justice actually drawn inspiration from municipal law or inspiration from state law. A case came up in the year 1928 and which is popularly known as the Corzu factory or the indemnity case. In the Corzu factory or the indemnity case, the Permanent Court of International Justice pointed out that the doctrine of res judicata is a general principle of law recognized by the civilized nations. Now, the doctrine of res judicata, which is found in the Civil Procedure Code in India or anywhere in some other provisions, is recognized throughout in almost all the legal systems of the world. Now, when once a particular case is decided on a particular point, the same case cannot be decided on the same point by the same court. Now, this is universally accepted. This is done with a view to do justice to the parties because they are not supposed to prolong the issue by citing one reason or the other. So a particular case, when once it is decided on a particular legal issue, it cannot be decided by the same court. So in the Corzu factory case in 1928, for the first time, the Permanent Court of International Justice, remember, put a seal saying that this is a general principle of international law recognized by the international community in most of the legal systems of the world. Now, thereafter, in the year 1924, another beautiful case came up. And this case, which is popularly known as the Mavramatis Palestine concessions case. In the Mavramatis Palestine concessions case, for the first time, the PCIJ pointed out that the doctrine of subrogation is a general principle of law recognized by civilized nations. Remember, there will be losers as well as winners. In the event of a particular person losing something, it is the duty of the winner to step into the shoes of the loser. Now, this has been recognized as a principle of law. You might be knowing the doctrine of subrogation. You will be studying in the contract law. And don't be under the impression this principle is only a part of the Indian law. This law is recognized in almost all the legal systems of the world. That is why the International Court of Justice in the year 1924, in the case which I have just mentioned, pointed out it is a general principle of law, commonly accepted, commonly practiced by the community of nations, and it has to be recognized by everybody. Now, there came in the year 1937 a case which is known as the Anglo-American what we call as the a beautiful case which was relating to what we call the sharing of the river Meuse, diversion of water from the river Meuse. And this case, which came before the International Court of Justice in 1937, and in this case, for the first time, the International Court of Justice pointed out the Anglo-American Equitable Doctrine is a general principle of law recognized by the civilized nations. Now, right from the time of Aristotle, or during the time of Plato or Socrates or any time, thereafterwards, when we come to the period of Romans, remember the principle of equity and equitable principles has been harped upon. And this has been continued even by the Roman legal system as well. And the British also recognized this. So for the first time, the court pointed out Anglo-American equitable doctrine is a general principle of law recognized by the civilized nations, and it has to be accepted. Now thereafterwards, remember there were several cases which came in, and in these cases the permanent court stamped that there are certain principles which are commonly practiced by the international community and to which the members of the international community, irrespective of developed, developing and least developed states, they are supposed to give respect to it. Now then came in the year 1945 the Charter of United Nations. Now the Charter of United Nations, remember, adopted again a statute of the World Court. When the statute of the World Court was adopted, remember, there they included four sources under Article 38 of the Statute of the International Court of Justice. You may be interested to know which are these sources. Now the first source happened to be international treaties. The second one is international customs. Now the third one is general principles of law recognized by civilized nations as a source. Then came judicial decisions as well as the writings of the most highly qualified publicists. So judicial decisions or the writings of the most highly qualified publicists naturally constitute as a secondary source of law. Now remember, for the first time, the International Court of Justice recognized in its statute general principles of law recognized by the civilized nations as a source of law. Now, having recognized this as much, there were several cases which came in. I shall just speak to you these cases which are very important, and most of the students who study international law as well as human rights study these cases. Now, one such important case happened to be a case which came up in the year 1949 before the ICJ. Now, what exactly are the facts of this case? Now, for example, remember the United Nations came in 1945. The United Nations had to employ several persons for the sake of maintaining international peace and security. They are called as the United Nations staff. Now, not only for the maintenance of peace and security, but even for administrative matters. Now, some of the employees who were employed by the United Nations were serving in different corners of the world. When they were appointed as truce negotiators, appointed for the suspension of hostilities in areas there prevailed hostility, and these United Nations employees were either killed or maimed by a gang of terrorists. So remember, an United Nations employee during the course of his employment, if he is killed by a gang of terrorists, by a forces, remember, it is just not possible to digest for any international institution. So at that time, what has happened was in the year 1946, there was a Swedish colonel, and this Swedish colonel, Colonel Bernadotte, he was a United Nations employee serving in the new city of Jerusalem. When he was serving in the new city of Jerusalem, he was killed by a gang of terrorists. And when he was killed by a gang of terrorists, remember there was a furor cry in the United Nations General Assembly. Ultimately, the General Assembly passed a resolution and decided to refer the matter to the International Court of Justice. When the matter was referred to the International Court of Justice, there were two questions which were posed to the court. The first question, in the event of an employee of the United Nations, during the course of his employment and service, if he is going to be killed or if he is going to be, remember, maimed, can the United Nations maintain a cause of action? Was the question. The second is, if the answer is yes, how compensation shall be paid either to the employee or to his legal representatives? Should this be through the state of his nationality or through the United Nations? Now, the International Court of Justice, having taken up the matter very seriously, as early as 1949, pointed out the international institutions have a personality of its own. Since United Nations is a person in law, it can sue as well as be sued in its own name. It went to the extent of pointing out 50 nations coming together collectively, having come together collectively and agreed to carry on certain things through a multilateral treaty, what is being decided by them has to be carried by them, and United Nations will have a collective will, and hence it is a person. And it went to the extent of pointing out United Nations has a personality of its own. It can sue as well as be sued in its own name, and it is empowered to maintain a cause of action, and it is empowered to maintain a cause of action against the irresponsible state who failed to protect him during the course of his duty. So that is how it came in. And for the second question, it said the United Nations can pay direct compensation which is collected from the recalcitrant state, and the matter it may be handed over to the concerned person or through the state. See, for example, what type of justice was done. So thereafterwards, remember, United Nations employees got a kind of security where even if they are killed, the United Nations will be there to take care of them for the first time. That is what we call as international justice at the international level. Now, the second case that came up happened to be a case which is popularly known as Curfew Channel case. Now, when I speak about the Curfew Channel case, now Curfew Channel is an international channel which is situated by the side of the state of Albania. And in an international channel, passage to ships of all nations must be given during peacetime. So it was an international channel situated by the side of the state of Albania, and passage to vessels of all nations must be given during peacetime. Now, what has happened was on 1946, May 15th, four British warships were passing through the Corfu Channel. And when four vessels were passing through the Corfu Channel, they were fired by the rocket batteries of the coast of Albania. So at that time, coastal batteries were maintained, and they used to fire through the coastal rocket batteries. Now there was some damage that has taken place to the British vessels. Now the state of Great Britain did not bother. Afterwards, after 3 months, there were again four British vessels were passing through the Corfu Channel. At that time, they were struck with the mines, and these mines were put by the state of Albania. The state of Great Britain did not bother. 21 days later, when the British warships were struck with mines in the coast of Albania, when they were passing through the Corfu Channel, they brought the mine-sweeping vessels and swept away the mines which were put by the state of Albania. It was at this juncture the state of Albania pointed out, here is a case wherein my sovereignty is being violated, and it complained before the Security Council of the United Nations. The state of Great Britain, being a member of the Security Council, they could not do anything. Later, the General Assembly, remember, drew a few questions and referred the matter to the International Court of Justice. Before the International Court of Justice, when these questions came up, the British government simply pointed out Corfu Channel is an international channel. In an international channel, passage to foreign vessels must be given during peacetime. If the passage is not free, it is the duty of the government of Albania to warn the navigating vessel saying that the passage is not free. And here the state of Albania has not done it. And instead of doing it, it has put deliberately mines. And only to see that the British warships are, remember, get damaged permanently. And when we passed in the month of May 1946, remember, they fired on our vessels with their coastal rocket batteries. Now, countering the argument, the state of Albania pointed out, here is a state known as the state of Great Britain, which has performed acts of sovereignty on the territory of Albania. They have come and exercised jurisdiction in our territory. This is untenable. It is totally unacceptable. Now, the court, having heard the argument, wanted to deliver justice to the parties. And when it pointed out, first and foremost, it pointed out, remember, during peacetime, no state is supposed to disturb international peace and creating problems for the maintenance of international peace and security. The state of Albania must not have fired through its coastal rocket batteries on British vessels. It must not have, under any circumstances, under any law, should have put mines in its coast and thereby causing damage. And during peacetime, passage to ships of all nations for 24 hours must be given. And it cautioned the state of Great Britain. It cautioned the greater state of Great Britain, pointing out no one is supposed to exercise law by taking it into its own hands. Now, if there are such problems, if your vessels were struck with mines, you should have come before the Security Council of the United Nations. We should have asked for an explanation. Individually, you cannot remember violate international peace and security was a decision that was given by the International Court of Justice, and this is being respected, admired by every scholar in international law even to this day. Now, the other one relating to international justice, a beautiful case came up, and this case is known as Anglo-Norwegian Fisheries case. Now, when I speak about Anglo-Norwegian Fisheries case, it was a revolutionary decision by the International Court of Justice. Now, those students who are very good in looking at maps, just see the map of Norway. If you look to the map of Norway, the coast of Norway is deeply indented and it is in curvature form. And when the coast of Norway, when it is deeply indented and in curvature form, remember, for them, it is not possible to adopt what we call as the low water mark method. See, the coast is deeply curvature form. And how do you adopt the low water mark at that time? To overcome this, the King of Norway issued a decree. And when he issued the decree, remember, he selected about 40 points. And these 40 points may be mainlands, islands, or it may be fjords, or it may be rocks, or it may be roadsteads. So it is on the line of the coast itself, within the coast. And remember, these points, it is called as the box matter. Some point may be a main island itself, or it may be a small place, or it may be fjords, or it may be rocks, or it may be roadsteads. And these four lines were joined. And outside these lines is called as the territorial sea. And inward side, it is called what we call as the internal waters. The state of Great Britain, when the King of Norway adopted this, objected to it. He simply said it is a violation of the customary rule of international law. And the state of Great Britain simply pointed out, under a customary rule of international law, the territorial sea has to be measured by adopting the low water mark method. On the full moon day or the new moon day, the water recedes to the lowest or in the coast. And that should be the line. That is called as the low water mark method. But then the state of Norway, it pointed out, see, it is not made by us. It is geography. It is geology. It is morphology. The geological features, the morphological features, and the geographical features, remember, refuses to adopt what we call as the low water mark method. In situations like this, we adopted the box method, selecting certain points and joining them. And the area outside is called as the territorial sea. The inward side is called as the internal waters. Now, the International Court of Justice for the first time accepted this principle. And in 1951, it was a revolutionary decision. It was unthinkable for anybody to accept such things. They said, where a territorial sea of a state cannot be measured by adopting low water mark method, it can adopt the box line method by selecting certain points. But then it's cautioned. When you select the box line method, the points which are being selected are not supposed to deviate from the direction of the court. So if they deviate from the general direction of the coast, it cannot be accepted. It should be parallel. and it should be in a position to help the state. Now, the state and a claim of the state to Great Britain failed in this case, is a in the leading case, wherein, remember, when once it was done, the principle which was laid down in 1951 became a part of the Convention on the Law of the Sea of 1958. And when the new Convention on the Law of the Sea came in 1982, which came into force in 1994, this was adopted. That is why it was a revolutionary decision, and it had far-fetching influence in the development of international law, because it was justice that was done to the state of Norway. One point I just intend to bring in here: the state of Norway and its people were exclusively living on the economic resources of the sea, the fisheries resources, which was very much essential. Now, the state of Great Britain wanted to go to the court because by adopting the baseline method, it lost almost 1,000 kilometers wherein the state of Great Britain would go for fishing. By adopting the new baseline, the state of Great Britain prevented, its ships were prevented from entering this 1,000 nautical mile zone adopted by the state of Norway. And this is an important case. Now, in addition to this, I just intend to speak to you certain other important cases. And these other important cases, remember, happen to be one is relating to what we call as certain expenses case. Now, this was adopted in this decision was came in the year 1964. Now, what is this certain expenses case? Now, remember, for purpose of maintaining international peace and security, the Security Council is in charge. Primary responsibility of maintaining international peace and security rests with the Security Council. So, Security Council is composed of 5 permanent members and 10 non-permanent members. And they are the ones who are supposed to maintain international peace and security throughout the world. Now, suppose due to some kind of politics, due to what we call as disagreement between the Security Council members, the Security Council is not able to act. Suppose during the course of a Security Council meeting, one state adopts a veto. And when one state adopts a veto, they are not able to take a decision because decision is not forthcoming. In such situations, can another organ of the United Nations take up the agenda which was before the Security Council of the United Nations? See, for example, there were several issues that came in. One may be the Congo crisis, or one may be the Lebanon crisis, or maybe the Moroccan crisis. I can point out many of them. But then there were different opinion because Security Council, due to the veto, lacked the teeth to bite and was not able to take a decision. In such situations, the issue came up: can the matter be referred to the Secretary General of the United Nations to put the same matter in the agenda of the General Assembly of the United Nations? And he did so. What has happened was, in the Korean crisis, the matter was put from the agenda of the Security Council to the agenda of the General Assembly, and the General Assembly immediately took what we call as United Nations peace missions. United Nations peace mission went there and it suspended the hostilities, and the armies from several states were given to the Security Council and the General Assembly. It went there. Now, what had happened was, the expenses which are incurred for this purpose on peace missions ultimately had to be approved by the Security Council and General Assembly. So the expenses for these peace missions which are sent to, or which were sent to, the state of Korea and other places came for approval before the Security Council. When it came before the Security Council, the state of Soviet Russia cast its veto. And having cast its veto, it said, we are not going to approve this, because here is a case wherein our powers are exercised by the General Assembly. Since our powers are exercised by the General Assembly, we are not doing anything. Sorry. Now, the matter then was referred to the International Court of Justice. When the matter was referred to the International Court of Justice, The International Court of Justice, having heard the case, pointed out, if you look to the Charter of United Nations, the primary responsibility of maintaining peace and security is with the Security Council, but not the exclusive responsibility. The Security Council is supposed to maintain international peace and security. But then, if the Security Council fails to maintain international peace and security, the same agenda can go before another organ which is also empowered to do justice to the parties. And what was done was right, and it had to be approved. And the approval of the General Assembly, the expenses can be cleared. This is what they said. See, what type of problems were there? And these problems, these types of problems were resolved with the International Court of Justice without any hitch. And that is where, when we speak on the day of International Justice Day, not only we speak criminal law, but then remember, for the adoption of criminal law, there were several disputes. In order to overcome these disputes, this came in. But the International Court of Justice, as a judicial organ, has done yeoman service for its for the purpose of adopting the Justice Day, International Justice Day. Another important case happened to be. See, most of these cases are not known to anybody. Some of them don't even study. That is the reason I wanted to bring home the facts of these cases. Another important case happened to be effects of awards of the Administrative Tribunal of United Nations. Effect of awards of the Administrative Tribunal of the United Nations, a case which came in 1954. Now, the United Nations, to carry out its objectives and goals, appoints several persons. And these persons, remember, from the side of the United Nations, are appointed by the Secretary General of the United Nations. It is the Secretary General of the United Nations who issues the orders of appointment. Now, when the orders are issued, now if he is empowered to appoint, he is empowered to terminate also. Now, what has happened was the United Nations employees who were working in some parts of Soviet Russia had leaked out some information. And leaking out information is considered as professional misconduct. Now, he sought a reply, but the reply was insufficient, and without asking the assent of the employees, a few of the employees were terminated from service. A few of them suspended, a few of them restored after the suspension. But those employees who were suspended and dismissed or terminated go before the administrative tribunal. Now, the administrative tribunal is a tribunal which is appointed by the General Assembly of the United Nations. And if you look to the Travax preparatories, that is what we call as the origin of the United Nations documents. Now we have the Constituent Assembly debates here for the Constitution of India. Similarly, there you have the United Nations adoption debates, which had taken place between 1944 1945. And if you look to it, it points out all the United Nations employees must be people with integrity, people with honesty, people with efficiency. So in order to see they give the best to the world, they should be the best in performance, they should be honest, they should be dignified people, and they should have the highest competency in service. And remember, for this purpose, in the event of a dispute between the United Nations on the one hand and the employee on the other, the General Assembly should appoint an administrative tribunal. And the administrative tribunal is a judicial organ. It should be a judicial organ. Now, this judicial organ came into force, appointed in 1945 itself. And the judicial organ had 7 judges. And these 7 judges, remember, are important qualified men with the competence in administrative law and international law. So what has happened was, in those cases which I have just mentioned, those who are dismissed and suspended from service, they go before the administrative tribunal. And when they go before the administrative tribunal, having heard the case in 1954, they have ordered 1.7 lakh crores of damages to these employees. No, that was too much amount. And it's not, no, so much of dollars. Now, in such situations, they said it came before the General Assembly for its approval in the annual budget. And General Assembly members were reluctant to approve this. They raised some issue. How can a body which is created by the General Assembly be bound to accept a decision created by itself? The General Assembly created the Administrative Tribunal. How a judgment of the Administrative Tribunal is binding on its creator, that is the General Assembly? We cannot accept it. Now, in circumstances such as this, the matter was referred to the International Court of Justice to give an advisory opinion. Now, the International Court of Justice looked to the Travex preparatories, and having looked to the Travex preparatories, it came to the conclusion all the framers of the United Nations felt that the administrative tribunal must be a judicial organ. When once the matter is decided by the judicial organ, it will act as res judicata. It will be binding. It cannot be reopened. It will be binding on parties. Unless, remember, the administrative tribunal has overstepped its powers. They, outside the scope of competence, they have acted. Then only it can be questioned, otherwise it is not. And the compensation that was awarded by the administrative tribunal must be respected by its creator, that is the General Assembly. See, we speak of administrative law today. When we speak of administrative law today, these are the aspects which come in there. How it has nourished, helped for the growth of administrative law and international administrative law throughout the world. This is one decision which naturally gives a hint of the problem. Now, there are two or three cases before I come to the other part. Now, one such case happened to be a case relating to what we call as Southwest Africa cases. Now, when I speak about the Southwest Africa cases, now this case is relating to the end of colonialism in all its forms and manifestations. Under the auspicious League of Nations, the League of Nations in the Treaty of Versailles created a mandate system. Those students who are interested may be interested to know what exactly is the mandate system of the United Nations. When I speak about the mandate system, remember in 1919 there were several states who are not in a position to govern themselves. Those states who are not in a position to govern themselves must be, remember, come under the supervision of the League of Nations. And the League of Nations will appoint a powerful neighbor to see that this oppressed region who is not in a position to administer comes under that. And it is the duty of the administering state to give good administration under the supervision of the League of Nations. So there were several states who are not in a position to govern themselves. And the the League of Nations appointed a body consisting of states, one state for these states. And they are powerful and they should take care of them and they should administer the territory and ultimately see that these states one day get independence. Now, what has happened was under Article 22 of the League of Nations, this was created. And South Africa was appointed as the administering state. It is called as the mandatory state. Then the Southwest Africa or Namibia was called as the mandated states. Namibia was a poor state, illiterate, ignorant, incapable of having a self-government. So in such situations, South Africa, being powerful, was asked to take care of Namibia, Southwest Africa. And it was the duty of the state of South Africa to give, remember, help under the auspicious United Nations. United Nations will also be there to give help, but day-to-day administration has to be done by it. Now, the South Africa, remember, its performance in Southwest Africa was very poor. Instead of giving or helping them, it wanted to colonize them. Now, that apart, in the year 1939, the League died a natural death. And in 1945, the Charter of United Nations came in. When the Charter of United Nations came in, naturally, Remember, they created a chapter which is known as the Trusteeship System of the United Nations. Article 76 to 85 of the Charter of United Nations speaks about the trusteeship system. Now, what is the trustee system? When I speak about the trusteeship system, even here also in 1945, when the charter came in, there were several states who are not in a position to govern themselves. Those states who are not in a position to govern themselves could come under what we call as the trusteeship system of the United Nations. Now, it is the duty of the trusteeship system to provide supervision, and it also provided what we call as the a state, a powerful state will take care of the state, a poorer state, and this powerful state naturally should give good administration and ultimately to see that one day it achieves independence. Now, what has happened was South Africa continued to remain under the Charter of United Nations as the administering state. In the first 2 years, it submitted reports to the United Nations about the welfare and its activities in Namibia. Thereafter, it refused to submit reports. So, South Africa, when it refused to submit reports, notice was given to the state of South Africa. Where is your report about Namibia? You are supposed to take care of the interests of the people of Namibia. You are supposed to safeguard the welfare of the Namibians. You are supposed to give good administration and protect human rights. Where is the report? Then South Africa bluntly said, I am supposed to submit report under the League of Nations. Now the League of Nations is a defunct organ. It has finished its course of life. When it has finished its course of life, where is the need to submit? Whom to submit? Then the United Nations said, no, that may be your answer, but then what is Chapter 12? The trusteeship system of the United Nations, remember, looks after the similar powers which were earlier exercised by the mandate system. And South Africa, when it did not agree, the matter went to the International Court of Justice. And when the matter went before the International Court of Justice, three questions were framed. The first, remember, question was, is there still any obligation on the part of South Africa to submit reports on Southwest Africa, that is Namibia? Should South Africa submit annual reports about its activities in Namibia to the United Nations? The second one is whether Chapter 12 of the Charter applicable to the territory. Chapter 12 relates to the trusteeship system of the United Nations. Whether Chapter 12 is applicable to the territory was the second question. Now the third important question is, can South Africa independently alter the contract of service that was assigned to it under the League of Nations? Now for all these questions, three questions, the International Court of Justice gave such a beautiful decision. Now it pointed out, first and foremost, the very purpose of appointing a trust territory is to take care of the people of the what we call as the trust territory. And for this purpose, we have appointed a powerful state to take care of it. And they should take care of it under the guidance and supervision of the United Nations. Instead of taking care of the territory, instead of taking care of the welfare of the people, it is trying to violate basic human rights. And for all the questions, he said negative, and it went to the extent of pointing out, here is a case wherein South Africa has violated the basic fundamental rights of the people of Namibia. Self-determination is a right. And ultimately, I just read, the very presence of South Africa in Southwest Africa or Namibia is illegal. And it is the duty of South Africa to withdraw its forces and to provide self-determination and pave for self-determination in the territory of Southwest Africa. See what decisions. This decision was, remember, referred to the international, the case was referred to the International Court of Justice thrice. Once in 1949, second in 1966, and a third one in 1971. Now, I was just quoting the sentence of the decision of 1971. The International Court of Justice decision, the first sentence, the very presence of South Africa in Southwest Africa is illegal. It is the duty of South Africa to facilitate, remember, self-determination. and pave way for the independence of the Namibians. Namibians should hoist the flag of independence. Sovereignty reside with the people of Namibia. That is where, remember, all this justice have been done to the poorest states. Poorest states were also recognized by the international community. And their honor, their integrity, their livelihood, all of them were taken care in the Southwest Africa cases. Now that afterwards we have another important case that came in, what we call as on law of the sea, that is North Sea continental shelf cases. Now, when I speak about the North Sea continental shelf cases, now you see just see the map, you will come to know North Sea is in concave shape. When it is in concave shape, remember there are three states which are situated on the side of the coast of North Sea. One is, remember, the state of Denmark. The other one is the state of Germany, and then the state of Holland. So the state of Holland, the state of Germany, and the state of Denmark are the three states. Now some scientists had predicted that within a few miles of the North Sea there are, remember, rich minerals and oil. And when there are rich minerals and oil within the continental shelf of the state of the North Sea, all the three states wanted to tell the rest of the world, saying that it is their territory. And they claimed, because they say went to the extent of pointing out their geographers and geologists have stated that it is the Germany went to the extent of saying it is theirs. Denmark said it is theirs. And the state of Holland said, what do you mean? We have been enjoying this territory for a period of time and we have the right to explore oil as well as minerals in this area. So instead of fighting, when the dispute arose, the matter was referred to the International Court of Justice. There was an agreement between Germany on the one hand and Holland on the other. And there was another agreement between the state of Germany on the one hand and the state of Denmark, and the matter was referred to the ICJ. Now, while referring or measuring the continental shelf, what principles of law are applied? What principles of international law are applicable while measuring the continental shelf of adjacent states? Now, under Article 6, Paragraph 2 of the Geneva Convention of the Law of the Sea of 1958, you have a provision, but then that relates to opposite states. For example, take it this way: India and Sri Lanka. So if there are opposite states, it says the median line. What is the median line? When I speak about the median line, suppose for example, you just take the state of Sri Lanka. On the full moon day, the water recedes the most. And from that point up to a particular level, it is entitled to enjoy what we call as the continental shelf, the territorial sea, and economic zone, whatever it be. And the same is with the state of India. Median line, remember, is the dividing line halfway through. Suppose, for example, there is a place like Dhanushkoti near Rameshwaram. From Dhanushkoti to Rameshwaram, the distance is the Dhanushkoti or Rameshwaram to Sri Lanka, the island, is about 22 kilometers. And at that time, when we measure the low water mark, 1 kilometer will be internal waters for both, and the remaining 10 kilometers the other side and 10 kilometers this side will be the line. So this is between opposite states. Now, how adjacent states should divide was the question which was referred to the International Court of Justice. The International Court of Justice, having heard the point, always it pointed out, first and foremost, where the legal regime fits in by means of understanding and agreement between the states, that should be prevail. That means if the states parties who are parties to the dispute, if they agree for a compromise by way of a treaty, and the principles that is being put down there by way of a treaty should be accepted as the law. Where there is misunderstanding, with the result treaty is not possible, and where there are overlapping areas. Now you may put a question to me and say, how overlapping areas come in? Now you might be knowing, when we see the natural prolongation of the land territory beneath the seabed and subsoil. Now you have the sedimentary rocks, you have the mud culture. Now they will say the mud culture and the sedimentary rocks found herein are of ours, and you don't find in your territory. So International Court of Justice pointed out where we have the same kind, the territory overlaps, there should be equitable principles. Equitable principles are to be applied in cases of this kind. And always, no, you may be knowing Aristotelian theory of justice, equal should be treated equally, unequal should be treated otherwise. Now the same analysis is said. The state of Germany here in this case happened to be a more powerful state which had the area was larger than the state of Netherlands. It was larger than the state of Denmark, and the population of the state of Germany was more than these two states. In circumstances such as this, Germany is also entitled to get a bigger share, was the decision. Now remember, the inspiration came in diversion of water in the river Meuse, which was decided by the predecessor to the ICJ, that is PCI, Permanent Court of International Justice, in 1937. Now, hundreds of cases have come. For example, there was a beautiful case which came in 1970, Barcelona Taxon case. In the Barcelona Attraction case, the International Court of Justice pointed out the principle of limited liability, which is practiced in the municipal law, is applicable even to this case. You may be knowing the principles of company law or corporate law is dependent or based upon the principle of limited liability. So what is dependent upon limited liability in the municipal law is also applicable to the rules of international law. That is what, remember, what is applicable in international law. That is, when I speak about this, these principles have been applied. Now, for example, two other principles happen to be the principles of good faith. The principles of good faith is a general principle, and this principle is recognized by almost all the nations. No state can say that the principle of good faith is not a principle at all. It is a general principle of international law recognized by the civilized nations. Principles of comparative law is a general principle of law recognized by the civilized nations. Basic doctrine of human rights, all the conventions on human rights, maybe you take it this way, the Universal Declaration of Human Rights, the Convention on Civil and Political Rights, the Convention on Economic, Social and Cultural Rights, the Convention, CEDAW Convention, remember, protection of women, the Convention of the Rights of the Child. All these, remember, are based on the basic human rights, which are general principles of law recognized by civilized nations, which is accepted as a document by the international community. Now, when we speak about the Rome Convention, remember, Rome Convention came in, it was adopted initially in the year 1898. No, sorry, yeah, 1988. But then, although it was adopted in 1988, it took 4 years to come into force to require the 35 ratifications. Today, it is being signed by more than 124 states. But then, remember, lots of work have gone for the adoption of this. Now, for example, for the adoption of the in the international convention, it developed soon after the establishment of the United Nations. The first move was started in 1935 itself, but it did not materialize. But at a later stage, remember, the state of Italy and some other states, some other Latin American states were interested in having a convention on international crimes and establishing the international court. Now, soon after the Nuremberg judgment, you might be knowing the Nuremberg judgment was adopted on October 1st, 1946. So, in the Nuremberg judgment adopted on October 1st, 1946, if I just tell you, now the allied Axis powers, the state of Germany, the state of Japan, and the other state, the state of Italy, pointed out these are all crimes that are committed by states. And for the crimes that are committed by states, individual cannot be booked. And these are all crimes committed by obeying the superior orders. And since the superior orders have been obeyed, you cannot make them liable, was the answer which was given by the state of the state of Germany, Italy, and the other state. Now in Japan, now in situations like this, how did the Nuremberg Tribunal answered? The Nuremberg Tribunal answered this way. I will be quoting the provisions of the Nuremberg Tribunal. Crimes against international law are committed by men. Crimes against international law are committed by men and not by abstract entities like states. States are incapable of committing crimes, and it is being committed by men. Only by punishing these men who are responsible in committing the crimes can the provisions of law, international law, be enforced. So nicely it was put. Now, since then, that is, first the Genocide Convention came in, then came in the Universal Declaration of Human Rights. There were several scholars who were championing for the cause of the adoption, what we call as the International Bill for the Criminal Code. But then it did not materialize. In 1958, another move started at the University of Harvard. And after it started, the University of Harvard, remember, at several places took up. But then again, remember, it remained then and there only. But then thereafterwards, in the year 1985, uh, some states, including the state of Italy and the Latin American states, took up the matter very seriously. And they pursued it, and they saw to it that the matter was put before the General Assembly. And they saw to it that a resolution was passed in the General Assembly for the adoption of a convention, and then began discussion. After discussions, several discussions that took place in several states, the convention was adopted. Now, when I speak about the international convention, first it speaks of the office of the registrar, then it speaks about the chambers, it speaks about the crimes that are being defined. Now, one important point that is being that one has to accept it, the Nuremberg principles are part of the statute of the International Court. Now, crimes against international law are committed by men only, and these men are to be punished. In the states, especially in the state of Africa, the African states are the largest to make use of what we call as this international court statute, the Rome statute. They have gone before the court, and afterwards they started claiming immunity. And recently, I remember I was part of the final round of an international moot on this international penal court, wherein it is worldwide. Uh, and African, they were giving the statistics. Africans were responsible in saying that an international court is very much essential, and self-determination, right to self-determination, has to be protected. The Universal Declaration of Human Rights have to be protected. The rights which are recognized under the civil and political rights conventions are to be respected. But then, when once they go before the court, they want to claim an excuse, with the result of nothing is forthcoming, and this should not happen. Now, rights are recognized, and the basic tenets and the freedom are being given, but then they have to be respected and they have to be enforced. And according to the recent trends, that the International Criminal Court, although has functioned very effectively, is not able to live up to its expectations. And that should not be the case. Remember, because if the states, having gone before the court, then afterwards raise certain issues which are not acceptable and which cannot be compromised, which are because they are against the basic rules of international law, the whole convention and its purpose will get defeated. And that should not happen. Thank you. Thank you very much. Yeah.
Hello. Thank you for enlightening us on the historical significance and evolution of justice through various disciplines of the ICJ, sir. We are very much delighted that we got an opportunity to hear from you. Now, I invite Kasturi Ajit to deliver the vote of thanks.
Any questions, doubts?
for that. Yeah. Any questions? Anybody have any clarifications or questions to be asked?
So, what is your opinion on Gulbhushan Jadhav's case, which was argued by Mr. Harish Salve before the International Court of Justice?
Yeah. What do you want on in that?
The present status, what would be the decision?
Now the point at issue is it is yet to come. The decision is yet to come, but India has been doing its work. But then the state of Pakistan intend to subvert by taking one reason or one pretext or the other. But India is alerted again, the International Court of Justice, and it has to be done in accordance with the prevailing conventions. And since India is not a party to the Rome Statute, the matter was taken there. And and here you have some other issues as well. See, one important thing is under the existing rules of international law, uh, uh, the right to return is a basic right. Suppose, for example, a national, if he wants to return to his country, he should be allowed to return. And here there is no such thing as coming back to the state of India because he is our national and the charges were framed against him for no reason. As if when he was coming from Iran, he was found there violating or doing some activities which are against the laws of the state of Pakistan. All these are being countered, but then if the matter is precipitated, naturally it will go before the International Court of Justice and arguments will be made, and India will be able to win. That is a fundamental thing. Other issues, many other issues are there relating to the case that are not required here. Yeah.
Thank you, sir. Do you think that the presence of Justice Dalveer Bhandari,
Ah,
the sole Indian judge, as a member of the International Court of Justice, would
yeah.
have some influence on this case?
No, naturally. Now what happens is, I will just tell you the other thing since you opened up the topic. Now, in the International Court of Justice, there is a provision for ad hoc judges. Now, ad hoc judges are appointed. Suppose, for example, in a dispute, now take it this way. In this dispute relating to Kulbhushan Yadav, there is a judge known as Kulbhushan Bhandari from the Indian side. Suppose the Pakistan state doesn't have. At that time, for that decision, in that case only, the state of Pakistan is empowered to appoint an ad hoc judge. Now, it came up for discussion in the Travex preparatories of the League of Nations. Why ad hoc judges should be appointed? Now, the reason that is being given is the ad hoc judges, when they sit along with the other 13 judges, totally 15, because when these have come, they are supposed to impress upon the remaining judges about the facts and the real situations of the case. So then some writers criticized this, they criticized and pointed out. Now, if they are supposed to brief and appraise every other judge of the court about their case because they belong to that state, what is the use of consuls? What is the use of a legal officer presenting the case? The legal officer does every job, and it is his duty to appraise everything, the pros and cons, the nitty-gritty issues of the case. But then they said, no, it is a tradition that is being followed because they get an opportunity to meet and talk in the corridors or during the briefing, and they will be in a position to explain the merits of the case to other judges, and that will help the international court to come to a very good decision. That is why ad hoc judge provision is being given under the statute of the court.
Thank you, sir. Thank you so much.
Anything? Anyone?
Thank you so much, sir.
Yeah.
Now I invite Kasturi Ajit to deliver the vote of thanks.
Good afternoon, all. Mar Gregorius College of Law is privileged to have organized this lecture on International Day of Justice. We are extremely grateful to Professor Dr. T.R. Subramania sir for accepting our invitation to become an integral part of this program. Thank you, sir, for enlightening us on the historical significance and evolution of justice through the various decisions of the International Court of Justice. Our heartfelt gratitude to our principal, Dr. John P.C., for his guidance in organizing this program. Our earnest gratitude to Reverend Dr. Koshi Isaac Punnamuttal, the Director of Margregorius College of Law, who encouraged and supported us, and our gratitude to our Vice Principals, Dr. Thomas Kutty sir and and Professor Ramachandran sir for their support to conduct this program. Our sincere gratitude to our head of the department, Dr. Jijimon V.S. sir, who has been instrumental in coordinating this program. Thank you all for the faculty members, especially Professor Vinulal sir, who actively organized all our online. We are extremely grateful to all the students for taking the time to become the part of this program. Thank you one and all. Thank you.
Yeah.
Thank you, Kasturi. We have come to the end of the session. We thank all of you for your participation.
Thank you. Thank you.
Very much, sir.
Yeah, yeah.
Thank you.
Listening to you.
Thank you, sir. Thank you. Thank you very much.
Thank you.